Hello and welcome to Legally Speaking with me, Tarun Nangia. The issue that we are going to raise today is very crucial to the development of India as a democratic country, the issue of public interest litigations. Now, Chief Justice of India, J.S. Kehar, sent a very strong message in the judiciary when he fined a litigant, an MLA from one of the states, rupees 10 lakh for filing a frivolous public interest litigation that was related to some newspaper article against him 2 odd decades ago, and so on and so forth. But then a lot of high courts in the country started fining a lot of litigants, but Justice Kehar made a very fine point saying that the time of courts and 3 sitting Supreme Court judges is very precious. It can't be wasted on reading, say, what you can say, hundreds of papers on seemingly frivolous matters. Now, to discuss this subject, we have with us 2 eminent panelists. One is Justice Mukul Madgal, welcome sir for the debate today, and also Sumit Kachwaha, an institution as far as the subject of arbitration is concerned. Now let me go across and take opening comments from Justice Madgal. Sir, what are your opening comments on the issue of PILs and the observations made by the Chief Justice of India?
Look, this was obviously a personal cause which was sought to be espoused as a public cause by an MLA. Yes. Defamation is a very, very personal thing. So I think the Chief Justice was right in imposing cost in this case.
Yes.
But the cost being imposed wholesale
in
PILs and all may not be very good, because if the genuine PILs get hit by it, then people who want to raise public causes will be deterred. And so it's like throwing out the baby with the bathwater. That should not happen.
So you mean it's a very, very sticky wicket as the issue is concerned?
Yeah, so since you are giving a cricketing analogy, yes, the ball spinning.
Yes.
Yes.
Okay.
It's a very tricky problem. If you look at the origins of PIL, started in the late 70s, Justice Mudgul had a role, in fact, in some of the original PILs. They were meant for, see, the whole philosophy was this, that we have these fundamental rights, beautiful fundamental rights, but then how do they serve the cause of the poor and the downtrodden? They don't know that there's something, this institution called the Supreme Court and High Court, and we can go out. The philosophy was that the courts must reach out to them, okay, instead of waiting for them to reach out to the courts. And 2 things the courts did. First, they said we're not going to insist on this local standards, so any public spirited person can come and espouse the cause. And second thing they said was that we'll do away with procedures. So simple letter or simple postcard will be treated and taken cognizance of. Now from these beginnings, which no one can ever fault on, especially in a country like India, this, frankly, the whole thing is spun out of control. Yes. And now you have all these married judges coming up with their personal philosophies and everything. So it becomes a mixed bag. You're the best of things coming out of PIL and you're the worst of things coming out of PIL.
Sir, I would like to interrupt at this point and would like to draw your attention to this one point. Justice Mudgal just pointed out that when there is such a judgment, genuine people may also fear. Do you think that is the risk we run, that people won't know what is genuine and what may be construed as frivolous? Or do you think litigants are very well aware of their frivolous?
See, no, let's not. It's possible that one man's meat is other man's poison. Yes. I mean, a person who's very much disturbed by something, he may think his cost is just so. I don't think the solution is to start imposing costs.
Yes.
And if you look at this recent spate of things, it's good that the Honorable CJ is leading this. That's a high time it was addressed. But most respectfully, look at the costs from 1 lakh to 25 lakhs. That has been the range in the last 6 months or so.
Yes.
So firstly, there is no measure of damage. It very much depends on how irked or how irritated.
But sir, if I may take the liberty to interrupt you at this stage, the Chief Justice of India, in fact, referring to his college days, he made a comment that when he was in college, Chief Justice of India J.S. Kehar, he was fined. Somebody in college was fined a very meager amount, if I recollect it right, and he said that I am a son of a rich father, so I can easily pay it. So then the college said that might as well we impose a heavy cost on you, so it acts as a deterrent to you. Do you think this heavy cost analogy, Justice Kehar...
This is certainly a theory in damages called a deep pocket theory.
Yes.
You pay according to what it hurts you.
Yes.
But the point is, how are we trying to tackle it? We are trying to tackle it if the court says that you have done something tremendously wrong and so I'm going to fine you. But the damage is done because the court time is already wasted.
Yes.
Number one. Number two, you have not put it on any sound jurisprudential principle. It very much depends upon how irritated the judge is with the petition before
It's psychological?
Psychological, he gets bugged because, but this is not going to work in half the situations, because what if there's a poor person who's going to recover cost from them? It's not. I think we must think of other solutions.
We must think of other solutions. That's the line I'm taking from you, Justice Mudgal. Is it psychological? And what do you think?
Let me come to really the origin of the PIL. To the best of my recollection, the PIL started by a condemned prisoner in Kehar jail, writing a postcard to Justice Krishna Iyer in 1977 or 78, which was treated as a writ petition because he complained about solitary confinement the minute district judge imposed a punishment. Justice Krishna Iyer treated it as a petition, appointed amicus curiae. My late senior Dr. Chitle was appointed as amicus curiae. I was his co-amicus. We went to the jail, studied the conditions and filed a proper writ petition based upon that, and that has led to the evolution. Now the PIL, the genuine PIL, as Sumit rightly pointed out, is for the weak and the oppressed who don't even know that there are fundamental rights, let alone courts.
So somebody else files for them.
Somebody else files for them, a good, well-meaning citizen, seeing the plight of the downtrodden, the weak, the forgotten, as Justice Krishna Iyer very beautifully described it in one of his judgments. So I think that is where the PIL started.
Yes.
Then rival industries trying to hold the other industry and putting up some front. Those are the kind of things which should be visited very heavily.
Yes.
When the court comes to a conclusion that this is a business rivalry masquerading as a public cause, is when the damages should be heavy. I mean, there should be some kind of a measure like that, as he suggested.
Yes. When a three-judge bench of the Supreme Court actually takes such a decision, would it have pained the judges somewhere that the court's time is seriously being wasted?
Yeah, correct. Absolutely right. The judges are bound to be concerned about. But there's one thing you must notice.
Yes.
That in such many of such PILs, notice is issued for the asking.
Yes.
I mean, the scrutiny is required at that level.
Yes.
Why issue notice? Finish it in the
first
first
you
hearing.
have yourself spent a whole life on the bench and you would have heard many such matters. Is it a worrying issue?
Well, it is a worrying issue, but the judge has to sift out the real from the unreal.
Yes.
And that is what his judicial training will help in guessing, outguessing or thinking why this PIL is filed. What is the timing? Somebody is coming out of the new plant,
yes,
and then environmental issues are raised,
yes,
because the rival industry is nearby,
yes,
who is going to suffer?
So
these kind of things must be visited with heavy costs.
Yes. So this PIL industry must be stopped, but not the genuine PIL.
Look, there are people who raise wonderful points in their PIL, but sometimes in this, as you said, sometimes irate,
yes,
judges, and were justified. Look at the pressure they have.
Yes, 60, psychologically affected.
No, 60, 70 matters a day.
Yes.
If one heavy PIL is filed, they go through it, they are justified. But they must see, as he said, there must be some basis, some criteria when to award what kind of a cost.
That's an important point Justice Mudgal is making. I'm going across to Mr. Sumit Kachwaha. Sir, I would like to draw your attention to the fact that the Supreme Court has asked all courts to impose exemplary costs, that is the word that is used, on people who file frivolous petitions, saying such litigation chokes the judicial system. That's the word that was used. A bench of Chief Justice J.S. Kehar and Justice D.Y. Chandrachud went on to say, and Justice Sanjay Kishan Kaul was also part of the bench, they said that liberal access to justice is leading to chaos in discipline, and the bench also quoted, and I would like to quote the bench, the sanctity of the judicial process will be seriously eroded if such attempts are not dealt with firmly. A litigant who takes liberties with the truth or with the procedures of the court should be left in no doubt about the consequences that follow. Now, we are at here, on legally speaking, are in a dilemma, because Justice Mudgal point out that it becomes very difficult, because you may in fact, people may fear to file a petition because, they may be, have to pay costs. Do you think that's an issue here, or it's very...
Can I come in here for
yes,
a minute?
Please. Yeah, please.
Look, this question of these observations are very relevant and pertinent, but this should be applied equally to normal litigation also.
Normal litigation.
People file false affidavits. I recollect in Delhi High Court in my tenure, only 2 persons being prosecuted, one by me, one by Justice Sen for filing a false affidavit.
Yes.
These observations must apply to litigation at large.
Absolutely.
Yes, not just
And
here.
second thing is, in litigation at large, the costs must compensate if hurt party, some defendant who's been dragged to frivolous litigation, please start imposing realistic costs.
Realistic costs.
The minute you start doing it in a PIL which is frivolous, which the court comes to the conclusion that it is filed by a rival industry, impose extremely heavy costs.
So that will deter anybody else from doing. Sir, I would like to draw your attention to the second comment, and would like to get Mr. Kachwa also know the same. The bench commented that frivolous and groundless filing constitute a serious menace to the administration of justice. They consume time and clog the infrastructure. Productive resources which should be deployed in the handling of genuine cases are dissipated in attending to cases filed only for the benefit of delay, by prolonging dead issues and pursuing worthless causes. So would you concur with the observation?
Absolutely. There can be no other point of view.
See,
but my only view is this should be not in PIL, also in other.
Yes, Mr. Kachwa.
See, Tarun, the harm is already done to the system.
Yes.
If a judge's precious time is taken,
yes,
both outside court and within the 4 walls of the court, in getting through this and arguing with some person who either has a personal agenda or he is just off his rocker or whatever, damage is already done. And I do not know whether this cost is alone going to be
a deterrent,
a right approach, or a deterrent, both. I think we need to do 2 things. First, the courts must lay down the checklist or the jurisprudence for entertaining PILs.
Okay.
Which means that there must be.
Do we need a code?
There
should be a code.
There is a judgment of the Supreme Court which lays down this. There is a registry which particular section which deals with PIL also.
Yes.
But nobody can stop a mentioning of a matter.
Yes.
That goes through the filtering process.
There are PILs where the person who's filing the PIL has zero homework.
Yes.
He's gotten up in the morning, seen some newspaper thing, and he thinks he should go and file a PIL.
But I would like to, sir, since you mentioned this, recently in the Delhi High Court, a bench of 2 judges came down heavily on a litigant. They in fact reprimanded him for saying that you get up in the morning, and that's what they said. You read a newspaper report, you file a PIL. Do you do research? Do you do your own study? Or do you think we are the one who have to now go through all this? If you're filing a PIL, you better be prepared.
See, therefore, first we need to have the 4 corners under which the courts will entertain a PIL. Second, and this is a bit of a radical suggestion, but it's not unprecedented, is that we must have a screening committee.
Screening committee?
Yes, of very eminent former judges or who are willing to sit as amicus curiae and allow it to go through to the next stage or not.
So you mean the bench's time is not wasted?
Exactly. There used to be something similar to that in the good old days. It didn't work out, but not for PILs, but for general SLPs, that they needed to carry a certificate of a senior advocate that he found it to be fit enough to be.
So the advocate would have produced the
matter. But that didn't work out because
that
people
was really for 130 review petition.
Okay. But sir, I would like to draw your attention. In fact, you at the start of the program, you mentioned that fining would really not be a solution.
No.
What is the solution actually?
No, fining is a solution in many cases.
Yes.
In many cases, like say where business interest,
yes,
things like this. Yes, fining is one of the solutions. The other is the Supreme Court has laid down these guidelines in a judgment.
Yes.
I don't recollect the citation, and the registry set up for this screening.
Yes.
But I think those guidelines have to be now enforced by the screening committee. Just now it consists of registrar, judicial, but as Sumit says, maybe the Supreme Court can go a step ahead and appoint eminent retired judges who are prepared to deal
I would like to
draw
your
sorry, can
yes,
I, if
please.
you don't mind, one more suggestion I have, second limb of what I was going to say, is that there must be a full disclosure of the person who's espousing the PIL.
So his credentials
yes,
must be...
credentials. Number 2, just as an arbitration you have of independence and impartiality, you must have a disclosure. Are you espousing someone else's cause?
Okay.
He must give a certificate. I know of NGOs who are set up with millions of dollars of funding from outside only to file PILs.
So these foreign funded NGOs affecting industrial development.
But this PIL industry is supported by them, but there is no disclosure. So the face of it, you have a very eminent lawyer, but you do not know that how the funds are filtering.
So you mean the foreign funded NGOs also constitute a PIL industry that operates in the country specifically for objecting projects in India?
Well, I'm not saying that their agenda may be right or wrong. They may be on the right agenda, but I am uncomfortable with the fact that somebody is funding people here only for PILs.
Mr. Kachwa has made a very interesting point of foreign funded NGOs and their interests and they constituting the PIL industry. We'll talk more on this, but let's take a break for now and we'll be right back. Welcome back. Just before going into the break, Mr. Kachwa explained how these NGOs who are funded by foreign interests are in fact running to a large extent the PIL industry in India. So could you explain a bit more on this and its implications?
Yes, I'll say the implication is in principle.
Yes.
In principle, you should not allow anyone to fund an NGO who makes it his business to file PILs when they're getting funded from outside, because then you're dancing to someone else's tune. At the least you should have is a disclosure. And I am not only talking of foreign funds. We happen to run a small little NGO in India, and we were told by one of our donors, they said that, oh, you are not filing PILs. I said, what do you mean?
Yes.
And they said, we will give you X amount of money as part of your budget. And obviously this NGO is getting money from outside.
So you mean where their motivations lie is not known?
Exactly. What agenda they are promoting, it may be good agenda, I am not on that. But there must be disclosure.
Disclosed.
And similarly, if you let someone give a certificate, yes, that he is not espousing somebody else's cause, he is not funded by anyone to file this PIL,
very important
directly or indirectly, and including, he must say that, because we know for a fact
many industrial projects in India have been held up because of PILs.
We know that so many, it's a standard ploy. Your rival industries coming up, you file PILs, you find 10 PIL. Respected industries are also doing it.
But sir, I would like to draw your attention with what Mr. Kachwa pointed out. We have had instances and stories, we can't confirm for lack of evidence, but countries who operate in and around the vicinity of India, so you can say neighboring countries, they would stop or bar through PIL setting up industries in India, because if industries are set up, then we won't export raw materials to that country because we will make the finished product. So
look, my view is, barring there are 2 or 3 persons who do PIL only but do a good job, solely motivated by good or the society, but the best results with the social conscience who take it up as a cause, but they are regularly practicing lawyers doing regular work.
I mean, this is a pro bono activity that they do in
pro bono activities, their social conscience urging them to do it. Barring 2 or 3, as I said, who do PIL only but do a good job,
yes.
I would say my limited experience shows that the best PILs have been by mainstream lawyers taking up social causes. And remember, PIL is meant for parties who can't speak for themselves, like this construction workers.
Yes.
That unorganized labor.
Yes.
Environment doesn't speak for itself.
Yes, yes.
There's nobody to speak for it. These are the kind of things where the PIL should be concentrated.
Okay.
Wherever a personal relief can be obtained in normal litigation,
yes.
PIL should not be there.
I would like to draw your attention to a comment made by the Chief Justice of India, J.S. Kehar. He said that every day we waste precious judicial time by going through these voluminous, frivolous petitions. These busybodies must be stopped. This is what he said. They are just busybodies. Why should we accept such petitions? These petitions are multiplying with each passing day. What is going on? Why should 3 judges of a Supreme Court waste time dealing with such thrash? Do you think that the apex court is suitably or say very irritated now with the kind of petitions?
Obviously, this is look at their pressure of work. Please realize, when I was practicing in Supreme Court,
yes,
till 78, the judges had about 40 matters,
yes,
40, 50 matters a day. Today they have 60, 70. Can you imagine?
Yes.
The pressure on them. So obviously irritation is there, and it is justified irritation. There's no doubt about that. But I think the screening process has to be strengthened.
Okay.
Exactly.
And
Screening
there is a judgment.
And since Mr. Kachwa spoke about the screening process, I would like to draw your attention, Mr. Kachwa, because the CJI said that we failed to understand what prompted the petitioner to file a petition before the High Court in 2015 in respect to a news article which was published in '94. So, I mean, that kind of delay. We also failed to understand why the petitioner filed an appeal in the Supreme Court against the December 16, 2016 order, which was explicit and clear. So, do you think that these cases, I mean, then after this whole thing happened where high courts were issued, what you can say, directions that they should be, do you think there is a mid path here that we can come at, that we can you can encourage genuine PILs and impose cost on frivolous?
This is Mudgal said, PILs were meant for the poor and the downtrodden and for environmental causes. That is what the real purpose is. But now you have a PL for anything and everything under the sun. You know, anyone who doesn't like anything in society, he just goes and does this. So there has to be judicial discipline also on this, because you know the courts can't be all over the place. They can't be running the country. They can't be second guessing everything which is happening in the country, including the height of the speed bumper.
Yes.
We had this case in the Delhi High Court hauled up the authorities as to why they do not make it mandatory for the pillion rider also to wear a helmet.
Yes.
Mumbai High Court said, how can you force someone to wear a helmet? So, you know, two judges taking diametrically different...
Sir, I would now go across to Justice Mudgal. In Delhi High Court, there have been a lot of PILs filed on cleanliness in municipal hospitals, of fumigation not being done, schools not being cleaned, and courts have issued directions. Because in a country when the executive fails in its duties, it's only the courts that come to the rescue.
Let me tell you what the role of the court is. It's to nudge the executive in the right direction, point them the path, and not get into the business of running schools.
Absolutely.
Yes, these are the causes, especially government schools, conditions and all, which PILs must be entertained, even suo motu.
Yes.
If Chief Justice sees, like Blue Line,
yes,
accidents killing people every day, was taken up as PIL by then Chief Justice M.K. Sharma, because I pointed it out to him and he referred it back to me. Today the blue lines are got. Of course the replacement is not much better, but they were removed because of a PIL, and I think Sumit will vouch this. There used to be accidents killing multiple people by reckless driving.
Yes.
So, but thereafter you should not say the buses should run like this and all. You nudge them in the right direction. You see, the Lakshman Rekha, so-called,
yes,
it could be bent for some time, but you must revert back and go behind that Rekha.
Okay.
In the sense, you nudge the executive in the right direction, point out what the duties are, but don't get involved in the day-to-day.
So, even this is the current conflict that is happening, where you know that Lakshman Rekha is breached. Do you think is?
I wouldn't like to call it a breach,
yes,
having been a judge myself.
Yes.
I would say the Lakshman Rekha can be bent for some time.
Yes.
But then you must retreat back,
Yes.
point out in the right direction, give a mandamus.
Yes.
But not the day-to-day monitoring is very difficult. We have so much areas of work.
Yes.
We cannot do it, and we cannot do it effectively.
Okay, that's a very frank admission by Justice Mudgal when he says that there is so much of work. I mean, this all can't be done effectively, and it's not. You know, you should know where to nudge. Mr. Kachwa, do you concur with Justice Mudgal?
Absolutely.
And how would you see because PILs are a fact of life; it can't be stopped. In your closing comments,
absolutely, very carefully thought of to the extent required. As Justice Mudgal said, that time may come to bend the Lakshman Rekha, but please don't break it. In paper, the Lakshman Rekha is there. The courts are not supposed to get into all this at all.
Yes.
On paper, we have laws called the Wednesbury principle, which means that the courts will interfere with the administrative decision only if it is so bad that no person in his right mind would come to that decision. That sort of a test we have. So we are leading a double life. On one hand, we have a Wednesbury principle. On the other hand, the courts want to run the country and tell the bureaucrats, and then it goes on rolling. It's not their job. Their job is to protect the fundamental rights of the people and to see that there is people do not exceed their constitutional limits. But if the judiciary is going to be all over the place, this PIL is not going to serve any purpose. That's
a very valid point made by Mr. Kachwa. Justice Mudgal, your final closing comments.
My comments are, good PILs have served great causes for the weak, the downtrodden, the silent things like the environment, the rivers and all. But this individual agendas should be stopped. Publicity agendas should be stopped.
That's a very important point made by Justice Mudgal. He said that genuine PILs should be encouraged, and also in fact pointed out the pitfalls. Sumit Kachwa also did the same, where he highlighted what are the pitfalls and how to encourage genuine PILs. Thank you so much, Justice Mudgal, for sharing or giving your time and coming for this discussion here at our studios. Thank you so much, Mr. Kachwa, for sparing time for this discussion. We will be right back in our next episode to discuss another issue, but thank you so much for joining us on this episode of Legally Speaking. Thank you.